Let's talk about an important case from the New York Court of Appeals. Espinal versus Melville Snow Contractors, Inc., 98 near 2 days, 136, 2002. At first glance, it's about snow removal, not cyber fraud. But the principle in this case is powerful, and it applies directly to cloud providers like Amazon Web Services when they ignore abuse reports. Background of the case in Espinal: a company was hired to remove snow from a property. Normally, if you're just walking by and slip on ice, you can't sue the contractor because they don't owe you a personal duty. But the court said there are exceptions. If a contractor takes on a job and people rely on it, the contractor can create a duty if they do the job negligently. In other words, once you step in to help or promise to help, you have to act with reasonable care. Legal principle. This is known as the voluntary undertaking doctrine. It means you might not have a duty at the start, but once you volunteer or create a system that people depend on, the law says you can't perform it carelessly. The court in Espinal made it clear: if you undertake a service, you must do it responsibly because others are relying on you. Applying it to AWS now, let's connect this to Amazon Web Services. AWS set up a trust and safety abuse report system. They encourage people to report fraud, phishing, and abuse. They issue official case numbers, like the one in my complaint, AWS abuse case hash 54816052471. By doing that, AWS isn't just a neutral host anymore. They've voluntarily undertaken a responsibility. They told victims, "Report here, we'll investigate." Once they accepted my reports, the duty arose. But instead of acting reasonably, like suspending fraudulent domains or escalating to law enforcement, they did nothing. They kept billing the scammers while the fraud continued. That's the exact type of negligent undertaking Espinal warns against. Why it matters in court. So when AWS says we had no duty to this victim, Espinal gives the answer: yes, you did, because you created an abuse report system, accepted complaints, and represented that you investigate fraud. In my case, I will use Espinal to show the judge that AWS can hide behind no duty. The law in New York is clear. Once a company undertakes to provide a protective service, even voluntarily, they must do it with reasonable care. AWS failed, and that failure harmed victims. That's why Espinal versus Melville Snow Contractors is more than a snow removal case. It's a foundation for holding modern tech giants accountable when they ignore abuse and let fraud thrive on their platforms.